all enjoyed Mr. Faulks' very informative overview of access to justice issues and the right to counsel in civil matters. If you're just joining us, welcome to the UDC Law Review Symposium on expanding the civil right to counsel. Next up, we would like to introduce Latisha Gotell Faulks. Professor Faulks received her JD from Rutgers University School of Law. Professor Faulks is currently a visiting associate professor at Atlanta's John Marshall Law School, where she teaches constitutional separation of powers, civil rights and civil liberties, and special challenges in constitutional law. Professor Faulks is here to discuss her article on the boundary between criminal appeals and post-conviction relief applications. While a direct criminal appeal falls within the scope of Gideon's guarantee of counsel in criminal cases, the Supreme Court has not recognized a post-conviction relief application as a process that falls within the scope of Gideon's guarantee, since it's a civil proceeding. So please join me in welcoming Tish Faulks, and I hope you enjoy the presentation.
Thank you. Good morning, everyone. I too will hide behind the podium.
Good morning.
And I know that I should have a PowerPoint, but I so enjoy my teaching that I want all of the attention here with me, so here we are. I was very pleased to see that we were going to step into the gap between what Gideon promised, and many have said has not fully lived up to, and the places where we recognize that poverty or lack of economic resources, but also support having appointed counsel. And my area of interest and expertise is the first intuitive step that you would take. So by a show of hands, how many people in the room are familiar with post-conviction procedures and applications? A few, which means I actually do get to be the professor. So, you're convicted of whatever crime you have. You effectuate your direct appeal, for which you are entitled to appointed counsel, not only a warm body ESQ, but also constitutionally effective assistance. It's not just that you have the body sitting there to make sure that you have an ESQ in the room. That person has to be engaged in the process of procedure. The Supreme Court has said you are not entitled to appointed counsel when you are doing your discretionary appeal. So you get your appeal as of right from your trial court to your appellate court. You are not entitled to appointed counsel for your petition to the state Supreme Court or for your petition to the United States Supreme Court. Of course, at the trial level, you had the presumption of innocence. You could hold the state to their burden. You could move forward and challenge everything that was presented against you, so on and so forth. My area of expertise comes in when we start dealing with the process that comes after your conviction is finalized, post-conviction relief. And post-conviction relief is interesting, and it's the place where I place my emphasis, because we now understand at least 300 times in the last 20 years, based on DNA evidence, that we have wrongfully convicted people who were actually innocent of the crimes for which they were convicted. Many of them served time on death row. The average sentence that was served before exoneration, 13 years. And you started seeing the exoneration so often that you've become numb to them. Man serves 23 years, exonerated following day, has a heart attack. So post-conviction is important because it's the place where we typically find those wrongful convictions and they come to light. Part of what comes to light in those post-conviction hearings, ineffective assistance of counsel. That is the promise that Gideon made, that you were going to have appointed counsel, that that counsel was going to test the state's evidence, failed. However, the problem is that your post-conviction relief hearing is a civil proceeding. Surprising? The thing that can reverse your conviction, the thing that can exonerate and clear your name, is a civil proceeding. Why? And I was really happy to see that we started off with the question of why we distinguish the two. Well, you no longer have the presumption of innocence. You've been convicted. As a matter of truth, when someone calls you a murderer, a rapist, a thief, it is a statement of fact. And you bear the burden of persuasion, of presenting your case otherwise. No need to have appointed counsel under those circumstances, right? Of course, you are incarcerated, completely and totally unable to get to the information that would demonstrate that your trial counsel was ineffective, that the prosecutor failed to turn over exculpable information, that the snitch who was involved in the prosecution was paid and lied and could not have been there. None of those things can you cultivate while you were incarcerated. Now, intuitively, what we understand is not just that you should have counsel, and that's the step that we're talking about here. Because the next step, of course, is going to be when you get civil Gideon, and the attorney who's taking on the case makes strategic error or professional error. Are we going to hold the client accountable for that, or the counsel? Now, my scholarship focuses not only on recognizing that we should have appointed counsel for post-conviction relief, because while it is civil in nature, it has criminal consequences, right? How many of you would feel comfortable recognizing that this person has been convicted of the rape and murder of a child? They claim that they are innocent, and we are not going to give them counsel to demonstrate their potential innocence. And really what we end up having to do is push to the state level recognition in state constitutional grounds that we should have this appointment of counsel, because the Supreme Court isn't hearing it. Let's see why. Well, first, of course, we have Gideon, which guaranteed the right of counsel. It incorporated the Sixth Amendment as applicable to the states. It wasn't until we get down to Evans in 1985 that you have a due process right and interest in appointed counsel for your direct appeal as of right. And then when we started talking about the post-conviction relief application period, the Supreme Court said, no, you're not entitled to counsel. That was Pennsylvania versus Finley, 1987. What are we looking at on the federal court to tell us that we're not going to have post-conviction relief? Well, we have Justice Scalia joining the court. We have the Warren Court no longer in place. We have death penalty reinstated. We have crime rate skyrocketing, drug crime skyrocketing, and the court recognizing that we are not going to move forward in expecting that we're going to have appointed counsel under these circumstances. But then we have, in 1992, Bloodsworth. Is anyone familiar with Mr. Bloodsworth? Mr. Bloodsworth was our first DNA exoneree. He was convicted of murder. He was sentenced to a death sentence at first. Upon retrial, he received a life sentence, despite the fact that he had information that indicated that someone else had committed the crime. And really, when you look at the wrongful conviction era, that is the place where we see the underscoring for the post-conviction relief need for appointed counsel. And the party that comes to mind for me that I have had the opportunity to meet, speak with, and really get to know his story and his and the way that I have shaped my belief about appointment of counsel was Daryl Hunt out of North Carolina. Now, Mr. Hunt was convicted of rape and murder. He received a life sentence. He was able, through the post-conviction process, with appointed counsel, to have the DNA tested, and it excluded him concerning the rape. The state's exclusive theory of the case was that Darrell Hunt acted alone, that he raped and murdered this person, and that he committed the murder to cover the rape. The DNA demonstrated that he could not have been the biological supplier, and for 10 years after the DNA excluded, Darrell Hunt fought to be released. And it is only because he had an attorney who was willing to continue the case, not because the counsel was appointed, but because the counsel believed in the justice of what needed to be done, that he was eventually exonerated. Now, the question that was asked at the beginning, what result without counsel? By today's date, we have 305 DNA exonerations. What result without counsel? The question hangs in the air, have we executed an actually innocent person? So far, we are reasonably certain that there has been at least one out of Texas. What result had he had appointed counsel? And it's the intellectual step from criminal process and procedure, of course we want appointed counsel, to critical stage of criminal process, civil litigation, of course we want counsel. Now, I'm very excited as I was listening to your presentation, thinking about family law and immigration and all of those things. And I'm concerned because of the lack of traction that we can get in the federal court. And we really do have a fundamental problem with federal court recognition of the importance of these issues as far as the criminal context is concerned. First, whenever we are presented with post-conviction concerns, this Supreme Court has seen fit to provide procedural relief. That is, we will waive whatever statute of limitations problems may have come into play to allow the presentation of information to the court, the federal court, to consider whether to provide a petition for writ of habeas corpus. That would be nice, except that procedurally we allow the tolling of the statute of limitations, and we continue to ignore the need of the person who is going through the process to have appointed counsel. Now, do they in fact have appointed counsel? In some instances, yes, they do. The Anti-Terrorism and Effective Death Penalty Act encouraged states to cultivate both a direct appellate process that had adequate counsel in place and to offer a post-conviction process through which one could be appointed counsel. The problem is that the appointment of counsel is not automatic, it's not presumed. There are, in many states, statutory provisions that would allow for appointment of counsel or appointment of counsel by court rule. Two problems. First, when seeking appointment of counsel at the federal level, a criminal defendant seeking relief has to make a prima facie showing that they have a viable case. That is, a prisoner must demonstrate all of the elements to demonstrate that they're going to have a chance before they get counsel to flesh out the chance that they've said they need. I can't imagine the average criminal defendant having the acumen to put forward claims concerning deficiencies in their trial without the assistance of counsel. Now, what happens in the federal court traditionally is that the criminal defendant merely picks up whatever briefing has gone on in the state post-conviction proceedings and presents them to the federal court. except of course to get appointment of counsel at the state proceeding, the criminal defendant, again, must demonstrate that they have a prima facie case without counsel, without access to prosecutorial discovery, without access to any means of investigating outside of the prison walls. And so we're basically requesting and requiring that a criminal defendant, potentially wrongfully convicted, potentially failing to have due process at the trial level because of ineffective assistance of their trial counsel, perhaps ineffective assistance of their appellate counsel, they are then left to bring all of that information to bear before the state court in the first instance, the federal court in the second instance, highly technical filings without any assistance at all. The second concern that I put before you, and the one that will come next in our discussion, is that even if they are appointed counsel, the Supreme Court has said all they need is warm body ESQ. That is, that party need not be professionally and constitutionally effective in the assistance that they provide, so long as they are an admitted attorney and they are there. Now, what is the worst case scenario when we think of that? Well, the worst case scenario is a highly compromised attorney, drunk, high, asleep, all would be fine. Really, all would be fine. And in fact, under current jurisprudence, an attorney that has been disbarred for mental impairment, substance abuse, financial impropriety, does not, per se, constitute an ineffective counsel in a death penalty case. So, what are we left with? My scholarship is interested and concerned with resurrecting what Justice Douglas identified as the equal protection concern with appointment of counsel for any case having criminal implications. And I use the term criminal implications very broadly because I anticipate things such as the post-conviction relief environment in which we're directly discussing. That's the heart of my expertise. Civil contempt, which looks and mimics criminal consequences. In some instances, when we are dealing with immigration concerns and deportation concerns, there's an element of criminality to the treatment of the detainee under those circumstances. And really focusing in on the fact that when one has financial resources, it dramatically changes their relationship with the justice system. And it is not just a due process failing that we do not appoint counsel, it is an equal protection failing, the nature of which we should not allow. Now, the research as I'm putting it forward and as I'm pulling together this glorious paper, you fall into a lot of different, let's say, rabbit holes. For example, I mentioned the Anti-Terrorism and Effective Death Penalty Act. It specifically bars relief, that is, the granting of a habeas petition because of ineffective assistance of counsel. I would put before you that such a provision within the statute is constitutionally invalid. The failure of an attorney at any level to represent their client in a constitutionally effective manner, in my opinion, is a constitutional catastrophe that should not be allowed. And please understand, stating that an attorney is constitutionally ineffective does not mean that they are a bad person. It doesn't even necessarily mean they're a bad attorney. Greatest practitioner I ever saw, John Bloom, requesting certain things in a habeas petition, made the statement, Your Honor, I cannot conceive of how I can be constitutionally effective without access to ... And it completely changed the demeanor of the court in how they were addressing the request that he was putting forward. I'm sorry, I said post-conviction. It was actually a death penalty sentencing. The entire demeanor of the court changes when it hears the attorney state, I cannot be constitutionally effective without X, because the appellate record is being drawn. I had never seen a counsel concede that they would be ineffective without. And in fact, the ego of many of us in the room would be, I am always at the top of my professional game. And the simple fact is, when we have limited resources, when we have a judiciary that is not open to the arguments that we're putting forward for why we need additional resources, we need to admit and concede ineffectiveness. In the post-conviction arena, currently, it would not matter. Now, that's my presentation. I think that I'm going to be getting us back on time, yes? I'm interested in what questions you have for me on how we're pulling this together. Yes, ma'am.
Considering there can be, at least in Maryland I know, unlimited motions to reopen post-conviction relief, is it your argument that there should also be the right to counsel for those motions as well?
Absolutely. And in fact, one of the questions that I've heard as I've gone through how to position myself here is how can I endorse constitutional right of counsel for post-conviction when there is no constitutional right of counsel for the discretionary appeal. And I think that really what we're talking about is a difference in what the petitioner, the criminal defendant, is going to have access to present their case. When you're dealing with the discretionary appeal, usually what the criminal defendant will do is they'll take the direct appeal as of right documents drafted by an attorney, they will repackage them and send them up to the discretionary court for consideration. The record is already kind of pulled together for them. When you're dealing with your first post-conviction relief application, or when you are making collateral attacks on that conviction, there is a development of the factual record that a prisoner just can't do within reason. And so I really think that when you're dealing with new claims or collateral claims that don't go to the case in chief, you need a professional legal mind to craft those particular claims and put them forward for the criminal defendant. And once they've been crafted, I think that the criminal defendant can rely on that crafting when they are appealing up even to the discretionary level. Now, the problem, of course, with filing your post-conviction relief application in the federal system is that if you have not pled it appropriately at the state level, the federal court won't hear it. And so perhaps what we're talking about is the constitutional right to appointment for your first state petition, with the assumption that that drafting is going to capture all of the collateral claims that couldn't go in a direct appeal and really pull them together in a professional way so the client can use those through the state proceedings and then back into the federal proceedings as well to satisfy the federal statute. Other questions? Yes, sir.
Structurally or functionally, would you, given the question, what would happen in Maryland, for example, would you think that something like the representation would come from an entity like the Public Defender's Office that would be able to manage that type of representation and ongoing representation?
I think that there are ethical problems with relying on the Public Defender's Office because that office, if they've been involved in the case in chief, will not be able, or ethically there are concerns with them being able to put forward appropriately the ineffective assistance of counsel claims for trial counsel and direct appellate counsel. What I am beginning to dream about are incubator projects, extensions of the clinical programs in law schools for graduated and barred students, attorneys, to fill in the gaps so that you have a private bar that is funded either through the law schools or through other governmental means to represent post-conviction applicants through that process.
Are we recording this?
I hope we're recording it. That is my official first pitch of idea for any law school that is interested, though I am only barred in New Jersey and DC. So, however, I am not afraid to take another bar. Other questions? Yes, sir.
Oh, you go ahead.
Yes, ma'am.
Thank you. Do you believe that giving the civil right to counsel in the post-conviction relief arena, like having appointed counsel, would be more feasible than getting the post-conviction relief labeled as a criminal proceeding? And if you think that the more feasible or more acceptable approach for a majority of people is the criminal route, do you think that undercuts the civil right to counsel argument?
Well, I think that there are enough fundamental distinctions in the post-conviction arena as compared to the criminal trial arena that it's appropriate that it's construed as a civil proceeding. The strongest argument that Justice Scalia has put forward for why none of the constitutional protections come in is because you no longer have the clean hands of an innocent person. And really, fundamentally, I don't think it's appropriate to try and shift the presumption of guilt upon conviction. And intellectually, I'm not smart enough to figure out how you bring it back under the criminal context without giving the government the burdens. That being said, I think that when you are dealing with critical stages of practice that have direct and substantial criminal consequences, including invalidation of conviction, our Constitution is a flexible enough document to anticipate that when those civil proceedings will have criminal consequences, the Constitution is anticipated to apply. That's not an argument that a strong textualist or a traditional reader of the Constitution is going to come to. But I think that the facts of how Congress has crafted the Anti-Terrorism and Effective Death Penalty Act and limited the ability of a criminal defendant to get any type of habeas relief, which they are constitutionally entitled to, would suggest that Congress has altered the nature of those proceedings enough that the Constitution should apply. Thank you. You just gave me a nice thing to think about in my paper that I need to quickly get someplace and jot down. Your question, sir.
I was wondering if you could talk a little more about the interplay with immigration proceedings. You know, so if the post-conviction relief application has immigration impact, how might that strengthen the analysis?
I wish that I could, but the immigration context is slightly outside of my central focus. It comes into my thinking and into my analysis now because of how the Supreme Court has stated that failure to advise a criminal defendant concerning immigration collateral consequences may constitute ineffective assistance of counsel. How deeply we go down that rabbit hole, ultimately, I'm not certain. Yes, sir.
So the question was asked before about whether or not the solution might be to make post-conviction proceedings criminal versus taking another, creating a right to counsel. On a similar front, could another approach be, if Gideon were better funded and the lawyers in the first place were actually more able to investigate cases, actually had the funding, we're dealing with these funding caps that made their representation so limited. To what degree do you think that would cut down on the number of post-conviction appeals? Do you think it would make a meaningful dent in the number of post-conviction appeals, or do you think there would still be a tremendous number of those that would need counsel?
I think that it would make a dent. I am uncomfortable with the idea that it would make a tremendous dent. Of course, prosecutorial misconduct, ineffective assistance of counsel are two of the leading contributors to wrongful conviction that we know of. The problem is that there are lots of other things coming into the criminal process and procedures that are not in the direct control either of the defense attorney or the prosecutor that are still of concern, and that still cannot be detected through the course of a traditional trial. And because of those other things that contribute to wrongful conviction, I think that the post-conviction relief process is still critical. And for some of the most difficult cases, I still think that that process is the only means by which we gain access and time, to be fair, to all of that other information that typically uncovers wrongful convictions for us. And to be intellectually honest, going to the wrongful conviction boogeyman is not something that's especially effective for the cases in which you have someone who is factually culpable, but legally may have been inappropriately convicted. Discussing those cases is much more difficult, especially to a lay audience which is really the audience that typically we're trying to persuade, that is the taxpayer, that we should even invest economically in appointing counsel beyond what they are traditionally comfortable with. And in Georgia, they're not entirely comfortable with financing even the Gideon promise that they've made for the death penalty. So, did I address fully what you were asking? Okay.
Thank you.
If there are no other questions, I am not quite at the end of my time, so we're back on schedule.
Good.
All right.
You.
Thank you very much.